Okay, good evening, everyone. Welcome to the finals of the 2025 Regents Cup competition. This is an opportunity to engage in Oxford-style debate on a topic related to free speech. The prompt the students will discuss today: when in conflict, constitutionalism should take precedence over public policy making. I'm going to explain to you the phases of the debate, and then I'm going to introduce the student teams and the judges. There are 3 rounds to this style of debate. In the first round, you will hear opening statements presented by one student from each team, the affirmative team, and then the negative team. In the second round, the teams will engage in cross-examinations. During this time, as your moderator, I will ask clarifying questions. Judges, during this round, you can raise your hand or just signal me, and you can raise your hand and I will ask you to present your question to the students. In the final round, one member from each team will present closing statements. At the conclusion of the debate, our judges who have received training in how to score Oxford debate will complete their scores for the event. We will post the individual tournament results on the Regents Cup webpage, which is azregents.edu/programs/regents-cup. If you didn't get that, we'll give it to you again later. Now it's time to introduce our student teams. We have Courtney Hoffman and Carly Vandermersch from Northern Arizona University. They are the affirmative team. We have Connor Hunting and Desiree Riley from the University of Arizona. They are the negative team. And I would like to introduce our judges. We have the Honorable Bill Montgomery, Supreme Court Justice, the Arizona Supreme Court. Laura Beltz, Director of Policy Reform, FIRE, Foundation for Individual Rights and Expression. Lyndall Manson, former Regent, Arizona Board of Regents. Keith Allred, Executive Director, National Institute for Civil Discourse, University of Arizona. And Luann Leonard, former Regent, Arizona Board of Regents. Thank you to all of our judges today. Judges, remember that you should be objective and unbiased as you listen and score the round today. Your score should reflect who you think made the better argument. Students, before we begin, please note that I will hold up a 1-minute sign when each round is about to wrap up. I will then announce the end of the round. Is everybody ready? Okay. Opening statements will be 7 minutes per team. The affirmative team goes first.
Before I begin, I would like to extend my gratitude to the esteemed judges, my partner Courtney, our colleagues at U of A, and the audience members, who many of which competed today, and I'm sure it's been a long day for all of you. I've had a great time, and we're honored to be here today. In every society, the social contract is the invisible thread that ties together the relationship between the government and its people. It's a promise that the government will protect our rights, uphold justice, and act in the best interest of its citizens. But what happens when that contract is put to the test? And the government is faced with a crisis or a national emergency. Is it tempted to break it? What happens when the rush to make policy decisions clouds the responsibility to adhere to constitutional principles? The truth is, without constitutionalism, as our foundation, the very trust that binds our government begins to erode, and with it, the freedom we hold dear. This is why we affirm that when in conflict, constitutionalism should take precedent over public policymaking. The Constitution is the ultimate expression of our social contract, ensuring that both government and the governed are bound by principles that transcend momentary pressures. Constitutionalism refers to the principle that government authority is derived and limited by a body of fundamental law. In the United States, this law is our Constitution. It emphasizes the importance of the rule of law, ensuring that government actions comply with constitutional principles and that individual rights are protected. Public policy, on the other hand, focuses on the specific actions and decisions governments take to address social issues or challenges. By times of conflict, we mean moments of national or societal crisis, such as wars, economic instability, or other situations where the government faces significant pressures to act swiftly and decisively. We base our affirmation on the following points. First and foremost, the Constitution stands as the supreme law of the land, surpassing any temporary policy or political decision. The supremacy is codified in Article 6, Clause 2, the Supremacy Clause, which declares that the federal law takes precedent over any conflicting state laws or policy. Its authority is not conditional or situational, it's enduring. This was solidified in Marvey v. Madison when the Supreme Court famously established the principle of judicial review, confirming that laws and government actions must be in line with the Constitution. In times of national crisis, when policies are often hurriedly crafted, the Constitution provides a stable legal framework that cannot be altered by the whims of political pressure or transient fears. Second, the Constitution is designed to prevent government overreach. History shows that in moments of uncertainty, be it war, economic collapse, or national emergency, governments are tempted to expand their powers in the name of security. The Constitution exists not to empower government, but to restrain it. It enshrines individual rights and structural checks and balances precisely so that no branch or actor can unilaterally act without accountability. In fact, many of the Constitution's most important provisions, the Bill of Rights, the separation of powers, and due process clauses, were written with the explicit purpose of limiting government authority, especially when that authority might be misused under pressure. Third, constitutionalism is the social contract that legitimizes the authority of our government. It is more than just a legal document. It is a mutual agreement between the governed and those who govern, outline the powers granted to the states and the rights retained by the people. In this way, the Constitution forms the foundation of political legitimacy. It binds leaders to a set of guiding principles that assures citizens their rights and that these are not subject to the shifting tides of political convenience. Upholding constitutionalism ensures that government actions remain not only lawful, but in adherence with our values, preserving democratic norms even under pressure. Without adherence to the Constitution, public policy becomes detached from the framework that gives it its legitimacy. Opponents of prioritizing constitutionalism may argue that it can be too rigid, stifling flexibility and swift action that may be needed to address urgent situations. They may contend that public policy must be dynamic, adaptable, especially in fast-moving, high-pressure scenarios where the government's response needs to be immediate. However, this argument fundamentally misunderstands the nature of constitutionalism and the roles it plays in protecting the very liberties they seek to safeguard in public policy. It is essential to recognize that constitutionalism does not prevent the effective governance in times of crisis. It provides the very framework with which governments can be the most effective. Flexibility does not require abandoning constitutional principles. Rather, it requires a government that understands how to act within those principles. In fact, the Constitution's design includes specific provisions for handling emergencies, such as power of the president to act during wartime, but even these actions are subject to oversight and judicial review to prevent abuse of power. Moreover, critics often claim that constitutionalism creates unnecessary delays in decision-making, yet the Constitution includes mechanisms that allow for swift action when necessary. The key difference is that these powers are carefully bound by constitutional limits, preventing unchecked executive action. When in conflict, constitutionalism must always take precedent over public policy. The Constitution is our supreme law of the land. It prevents government overreach and ensures legitimacy of legal and political authority. Upholding constitutional principles, even in times of crisis, is essential to preserving the rights and freedoms that define our democracy. Public policies focus on the specific actions and decisions of governments take to address societal issues, while constitutionalism, it emphasizes the principles and the limitations that govern those actions, ensuring that we are a government of laws, not of wavering political ideology. Thank you.
Thank you. And now we will hear the opening statement from the negative.
All right, before my time begins, I would like to just extend a thank you to everyone here, our judges, all the teams, moderator. I have to extend a thank you to my parents who flew here from Washington, my debate coach, Ted, who has been with me for 4 years and really helped me grow as a person. I, of course, have to thank my team and my partner, Desiree, who has been a fierce debate partner and a partner through traversing life. I want to thank everyone for being here at the end of a long day. I couldn't be happier, really, to be right here. I'm a senior. I've done Oxford debate for all 4 years, and this is the last debate I will ever do. And I want to say, I couldn't be happier it's this topic, because in all my years of debating, I have never felt initially so confused on how I would argue against the Constitution, everything I stand for. It seemed to fly in the face of everything our country stands for. Argue against the Constitution? How could I even possibly defend something so un-American? But we realized that is not what this site is about. We're not here to argue that the Constitution should be ignored or disregarded or even trampled upon. The Constitution, of course, is the backbone of our democracy. But what happens when there's rigid adherence to the constitutional text and it undermines the very principles of the Constitution? We want to clarify that when we're talking about the Constitution and public policy being in conflict, it's not during times of conflict. It's when the two precedents are in conflict themselves. History has shown us that in moments, we have two choices when dealing with the Constitution. We can cling to the literal text and risk collapse or dissolution, or two, we can adapt, interpret, and stretch constitutional provisions to preserve democracy itself. We take the second view, not because we disrespect the Constitution, but because we value its very survival. We have two key arguments. One, we have repeatedly needed to reinterpret parts of the Constitution for specific cases to preserve its spirit. This is the invisible ink on the Constitution. It's the judge's interpretation. Two, there are moments when strict constitutionalism has threatened our very own democracy. Before we delve deeper, it's crucial to establish our understanding of constitutionalism. As we define it the same way predominantly used by the courts, originalism, which interprets it based on the meanings commonly understood when the text and amendments were actually ratified. In most cases, we fully agree that this is valid and preferred because it anchors our legal system in historical precedent and intended meaning, providing consistency, predictability in judicial decisions, strengthening our legal bedrock of the Constitution. While this bedrock of the Constitution provides a stable, valuable foundation, like glass, it can shatter under too much inflexibility, where bending slightly is preferable to breaking completely under the pressures of modern challenges, which we are seeing more and more every day. And this is where public policy making taking precedence comes in. The Constitution's primary function is to protect our key rights, but it also must empower people to bend the government to their will. Herein lies our core argument. Public policy should at times take precedence over constitutional provisions, not to undermine the Constitution, but to ensure that it does remain a living, evolving document that adapts to contemporary challenges and truly supports the people it was designed to protect. One of the clearest examples of necessary adaptation is the expansion of federal powers under the Commerce Clause. Congress has used this for wide-ranging policies, from child labor to Social Security acts, and even prohibiting racial discrimination in private businesses. This was never in the original Constitution. These cases involved reinterpretations of the Constitution that violated strict adherence by taking powers traditionally reserved to states. However, if we had taken a strict reading of the Constitution and the Commerce Clause, basic worker protections and social services may not exist, and racial segregation could still be legal. That's not something we truly want to promote as our country. We have to live under this flexibility. Not only could our country be worse off, we might have even lost our country. During the Civil War, Abraham Lincoln suspended the habeas corpus and fought the Confederacy before Congress made a formal declaration of war, an undeniable violation of constitutional rights, as these powers were explicitly reserved to Congress. Strict constitutionalists, like our opponents at the time and some today, called Lincoln a tyrant. But had Lincoln followed the Constitution to the very letter, the Union could have fallen, and with it, our own democracy. Not only have we seen Congress and the President stretch the Constitution, we've seen this in the courts, when they deviated from the strict adherence of for vital public policy reasons. An example of this is the 14th Amendment. The 14th Amendment guarantees equal protection under the law, but under strict constitutionalism, Plessy v. Ferguson in 1986 that allowed racial segregation under the separate but equal doctrine. This followed strict adherence, as segregation had been understood explicitly to be allowed under the 14th Amendment, given that the state and the government that ratified it also segregated schools. When the Supreme Court banned segregation in Brown v. Board, they did not claim any strict adherence to the text, but rather appealed to the nature of our constitutions as a living and breathing document that needs to be adapted to address public policy needs. If the court had adhered to strict constitutionalism, reading it line by line and literally, the following text's original meaning, segregation would have remained legal. Not only have we stretched the Constitution for vital public policy reasons, but we have also undermined our system through strict adherence. We saw Citizens United versus the FEC, in which First Amendment rights were held to prohibit restrictions on political expenditures. Originalists lauded the decision, viewing it as supportive of speech protections. However, it eradicated our very few policy restraints on political spending and unleashed the floodgates of wealthy dominating elections. Another example is the unitary executive theory, which is that all executive power rests in the plan. We plan to discuss this during the round and expand our view on this. In both these cases, our strict adherence to specific provisions has undermined our complete system and will still have ramifications. Ultimately, a constitution that cannot adapt to public policy is like an iron that cannot bend. It will break under the pressure of change. Flexibility is not the foe of structure, but it is the very key to the survival. Thank you.
Okay, we are now going to move into the cross-examination round. This will be approximately 25 minutes. I will throw up a sign that says we're close to time, around 22 minutes. And I will start off with a clarification question for the affirmative team. What criteria should be used to determine when constitutionalism should override public policy?
Okay. Is that when constitutionalism should override public policy is when we're at risk of threatening the key values and rights that our founders enshrined upon us. Those they felt through the Bill of Rights were the most important and fundamental aspects of our democracy. And so when we go through suggestions for public policy and they occur through times of crisis, we need to make sure that constitutionalism, especially overriding public policy when those values and rights are at risk.
And what we would say is that, and what we would say is that constitutionalism and adhering to strict constitutionalism actually is bad for society, because we have one of the shortest constitutions of any nations. And so we have to interpret it. We have to allow for the flexibility, because without doing so, we actually disparage Americans the opportunity to grow with our country. And so we have to look for things like structural changes, societal changes, and we have to look at the Constitution truly as a living, breathing document that can support public policy, not be in conflict with it.
And to add to what Connor was saying there, we've seen time and time again throughout history that strict adherence to the Constitution has actually prevented rights from being given out and distributed to the citizens of this country. Connor talked about in his opening case, Plessy v. Ferguson, where the court upheld racial segregation under the separate but equal doctrine. We would argue that public policy would have been significantly better in that place. And remember from when we were talking about the Voting Rights Act earlier today in round one, for many of you who watched or participated in it, with Shelby County v. Holder, the decision gutted key protection of the Voting Rights Act. That was the public policy that made sure that citizens were able to vote. The court said that the federal government could no longer require plea clearance from states with histories of voter suppression. And almost immediately afterwards, what did we see? We saw states like Texas, Georgia, and North Carolina passing voter ID laws that were more strict and closing polling locations that disproportionately affecting Black and brown voters.
In response to that, the definition as we define constitutionalism just refers to the principle that government derives its authority from a fundamental law. In the context of the United States, this refers to the Constitution. We're not advocating for strict or inflexible constitutionalism as we defined it. We recognize that the Constitution is not a static document. The framers knew they couldn't predict a lot of the modern challenges, and its genius lies in its ability to adapt. That's not strictly done through public policy, but rather they embedded principles like due process, checks and balances that are broad enough to allow us to adapt constitutionalism to modern day needs.
And that is the flexibility that we are absolutely arguing for. However, the definition that the Supreme Court uses is that of originalism, which means the Constitution is taken line by line and literally a lot of times. You might hear stuff about something called the invisible ink. This is where judges move outside of the Constitution. They interpret it in different ways in order to better fit society. That's what we're arguing for. And under the definition of originalism, we have to look to public policy, not constitutionalism.
And for a question for the affirmative, can you give us an example of public policy that doesn't adhere to at least the morals or ideals of constitutionalism? Because if you're going to take this argument that it's just we're looking at with constitutionalism the ability of it to adapt, then that means we're all achieving the same goals. Constitutionalism is going to be that of the rigidity in order for them to be two distinct things in conflict.
Is my mic on? Can you hear me? Okay. Yeah, so that's a fantastic question. So our response to that would be the Patriots Act. It's a warrantless wiretapping secret surveillance act, and it breaches the Fourth Amendment. So that is an example.
In your opening, did you say that in times of conflict, though, the Constitution provides power to the president in certain situations? Because the Patriot Act was mainly the workings of George Bush, and so that would be adhering to strict constitutionalism.
To being mic'd. Oh, just keep them on? Oh, okay. Thank you. I apologize. I'm so sorry. Yes, but it was supported by the federal government beyond just Bush. And so the Supreme Court or courts later did find that those provisions were unconstitutional, and it is still a form of public policy that was later found to be unconstitutional.
Well, that wasn't the question. The question was if it was a strict adherence to the Constitution or not.
The Patriot Act?
Yeah.
No.
May we have a question?
Yes.
Yes.
So you mentioned that the Constitution is too rigid, but doesn't it already include flexibility possible within constitutional bounds during times of emergency?
I mean, potentially, but more examples propose that in times of emergency, conflict, or pandemics, we adhere to strict constitutionalism and it results in negative afflictions. So, for example, if we're looking at Formasu versus the United States in 1944, this is when the court upheld that internment of Japanese Americans during World War II, accepting that it was national security justified. And so this was strictly adhering to the Constitution. By doing so, it allowed us to put Japanese Americans in internment camps. And it was grounded and upheld under the banner of constitutionalism. So in times of conflict, adhering to the Constitution can actually infringe on the rights of minorities, and it's just generally not the best principle to follow because the federal government moves pretty slowly, but public policy can react very quickly to things like wars and pandemics.
Yes.
I have a follow-up to that. Was public policy not what ultimately implemented all of the examples that you just gave, though?
Can you clarify what you mean?
Well, you gave some examples of of the internment camps and that blaming it on the Constitution and the strictness of the Constitution. But ultimately, weren't the public policy makers the ones who implemented all of the things that you just brought up?
I don't believe so. I believe it was the federal government doing that, and it was ruled as constitutionally grounded. So it was taken to the Supreme Court and it was considered justified due to strict adherence to the Constitution.
The federal government is allowed to participate in public policy making. So whether or not they initiated it or not, it was still a form of public policy that was first initiated and then went to the courts to determine constitutionality. So it's actually an example of times when we reacted in the extent of a crisis and developed public policies that hurt people within the US.
But was it not upheld under the Constitution?
Yes, but it wasn't made, it was public policy first.
Right, but the point we're getting at is that if you're advocating for the Constitution and it's supported for it, you're saying the Constitution is supposed to be the supreme law of the land in your words. So if the Constitution is able to uphold policies that are bad, then why are we still looking at it under strict adherence?
Yeah, that was a great question. So under your definition, public policy making is something that interprets the Constitution. So what we're seeing as is public policy making is ultimately interpreting what the Constitution states and then is applying it to the various different rules that are being implemented.
We do have a question from Judge Montgomery.
So I've listened to the arguments for interpreting and applying the Constitution, but I wonder to what extent does Article 5, which allows for the Constitution to be amended, play into either team's argument?
I think it supports our argument for constitutionalism. That's a great vein in which the U.S. Constitution is allowed to be amended to reflect modern values, and then public policy can extend from there. But again, we have that deep rootedness, and constitutionalism comes first, public policy follows.
And it absolutely can be amended. And we would like to recognize, though, that that doesn't happen very frequently, and it is a very lengthy process. It does add room for the courts to interpret that, but we still have to adhere to what is said in the amendments and what is said in the Constitution. So it might make for more ground, but it doesn't totally stifle the Supreme Court from interpreting based off of a strict adherence.
Yes.
But to talk about the rigidity of the federal Constitution, to what extent does the flexibility of state constitutions play into your argument?
I think, again, state constitutions are derived from our federal constitution, and so they reflect the values and democratic principles that we express in there. And so even their constitutions fall back on our federal constitution as a guiding principle, which then informs their public policy as well.
It's an interesting question and an interesting take. I think when we're looking at state constitutionalism, we can see a lot of the same principles. Although we will acknowledge that state constitutions can be amended easier. However, when looking at things like public policy during the pandemic, many state constitutions had provisions that made it hard to interpret or get around certain areas. And so following it line by line can be dangerous in any situation. But if we look to lawmakers in that situation, we might find more success.
And additionally, state constitutions vary on a state by state cases. And so to add on to what Connor's saying with this point is that sometimes public policy is needed in those instances when a state has a constitution that doesn't necessarily deliver rights to their people.
Judge Allred.
So one of the classic cases has been brought up to justify occasional departure from another classic case that is brought up often is the Louisiana Purchase under Thomas Jefferson. Most consider outside of a strict construction. So questions to both sides. Was that the correct decision? And was it within constitutional bounds or not?
I mean, we can go first because we talked about that within our case, and we would say that 100% it was the correct decision. But Abraham Lincoln went against the Constitution at that current time in order to do it. The Constitution.
Question.
Okay, sorry, can you rephrase your question one more time for me?
So habeas corpus is one of the leading examples. A second leading example is when Jefferson did the Louisiana Purchase. Many claim that was an exercise.
I would say that it absolutely was the right decision to make, but we have to remember at the time, the Constitution was fairly new. And so he was going outside of the Constitution, interpreting it in a way, if you will. And so he believed in the power of public policy and executive order in that fashion. So he might have gone against the Constitution or tested its power and flexed it, but the Constitution was very new at that point. And so it wasn't a strict adherence to constitutionalism at all. It was, in fact, a sort of liberal interpretation of it.
I would say that we would also agree. We would think that it is the correct decision, but our reasoning would be a little bit different. We would say that he did follow more of the constitutionalism and he did interpret it. But ultimately he relied on the Constitution and not really public policy making, considering it wasn't really being implemented into the people. So I think that that kind of example falls a little bit more onto the affirmation side of why constitutionalism should take precedence.
I mean, we would disagree that Thomas Jefferson strictly followed the Constitution. He himself was quoted stating that laws of necessity to save our country when in danger are of higher obligation than strict adherence to written law.
Yeah, I think a counterpoint to that would be he didn't follow it to the T, but he definitely did use it as like a guiding line. He used the Constitution as a guiding line for his own principles.
Again, there's a distinction between constitutionalism and the moral and foundational ideas of our democracy. Making sure that justice is given to all is a foundational principle of our democracy. But it's the rigidity of the Constitution doesn't always apply that. While Thomas Jefferson might have been able to grab concepts and ideas of to what we wanted freedom to look like in this country, he wasn't strictly applying to the Constitution.
Again, constitutionalism as we defined it in our affirmative statement doesn't lend necessarily to strict interpretations of it, but rather recognizing that the values and principles outlined in that document are the foundation of our democracy, and in times of crisis, those are what should take precedent over policymaking.
We have a question if nobody else has one. Any of the judges?
I think we're good right now. Go for it.
What gives public policy the authority to override foundational legal principles?
I mean, that is a loaded question. I'll do my best to answer it. I mean, we're going to argue that public policy, it never has the intention really of going against legal principles, but rather working within them, or as we're saying, stretching and testing the flexibility of it. And so when they're making those actions, things like during the pandemic, there was a lot of laws passed very quickly and time couldn't catch up. The law couldn't catch up with the time and the precedent. And so we had to look to public policy. And so in times of conflict, sometimes we have to think about what is better for protecting democracy as a whole rather than upholding a written document.
I recognize that you mentioned flexibility, but with flexibility can come instability. Flexibility may sound appealing in practice, easily adaptable, but it means that rules can shift with political winds, and that can be dangerous to the foundation of our democracy and to the foundation of the social contract.
Well, I think we have one thing on agreement, and that's that too much flexibility and too much adherence to the structure of something can both be dangerous. And so we have to find a common middle ground between the two. And we would say that's public policy because there's more oversight over public policy. Strict adherence is just as dangerous as too much flexibility, if not more.
Our opponents are wielding a double-edged sword with this one because they're saying that they want constitutionalism to be something that is able to have flexibility and adaptability, but at the same time, they're saying that flexibility and adaptability can be not good. So it's unclear what your line is there.
In reference to public policy, as you stated, flexibility and adaptability can be detrimental because, as you stated, it can occur quickly. Constitutionalism, we derive the power from the Constitution and we are able to adapt and amend that. The processes are, yes, a bit slower than public policy, but that reasoning comes from the fact that we're ensuring that they are rooted in the values instilled in the Constitution and that what we are doing and the actions that we are taking follow those values outlined. That's constitutionalism, how we are adhering to our democratic principles and values outlined in our governing document, the Constitution.
Can I ask a question?
Mhm.
If the Constitution is a living document, what makes it a living document?
That's a fantastic question. So what makes the Constitution a living document is it's still something that we use today. It's something that we still base our democracy on. It's something that we base a social contract on. It's a living and breathing document that we still use today as the foundation of our democracy.
For us, the living portion of the Constitution is reflected in the citizens, the interpretations, the flexibility, that invisible ink to interpret and fit citizens as they are today. I'm sure our founding fathers would be looking at us in this room and they would be surprised by all the ways that we flex the Constitution. But I would argue that that is what that very nature is what allowed us to survive for so long and thrive with such a short document as our Constitution.
And we would counter that the flexibility of the Constitution comes from its ability to amend and change it, which by extension reflects the will of the people. And so that would be our counterpoint to that.
Judge Albright.
This is a very interesting kind of difference that the two teams have staked out in terms of how to, interpretive lens of the social contract or originalism. For the affirmative, if there was a public policy that passed the Congress with 90% bipartisan support and had greater than 90% popular grassroots support, but was at odds with the Constitution, is that right in the social contract?
I would say no, because it's still the people that are speaking towards the Constitution. Those are the representatives of our country. Those are people who have our best interest at heart. So they do have that fundamental principle of democracy, the social contract, constitutionalism instilled within them. And whether or not it strictly follows that document or not, they're the representatives of the people. So I would think that it would still follow constitutionalism.
So for us, under Citizens United versus the FEC, which established that corporate spending in elections was pretty much unlimited, it was widely unpopular with Americans and even many corporations. But strict adherence to the Constitution allows that to be upheld. So it's not popular and society as a whole doesn't really reflect it, but under the strict adherence, the courts did not strike it down.
The social contract is what we need to look to. The government exists to serve its people. You give up some rights in order for the protection of others. So in the question you gave where if 90% of people wanted it, We'd argue that if it was unconstitutional, then it's violating that social contract that we have with the government.
And we argue that there are aspects of the Constitution, like the 14th Amendment, that allow bills and acts to be enacted in the name of protecting certain rights that would grant authority to kind of change and amend the Constitution to reflect the will of the people.
Questions from judges? I will ask a question about interpretation. Over time, you've mentioned the interpretation of the Constitution, but that has changed over time. How will that affect society as we go forward?
That is a fantastic question. So today's resolution is one in conflict. Constitutionalism should take precedence over public policy making. And so what we've seen with the different interpretations of public policy making as the years, the decades, the centuries have gone by is ultimately we still look to the Constitution. The Constitution is the backbone of our United States. It's the backbone of everything that we believe in, the backbone of our democracy, the social contract. So that's why it must take precedence over public policy making, because regardless of what the interpretation is of that current public policy making, we ultimately do look to the Constitution to guide us.
And we can understand and agree with many of those sentiments, such as the Constitution being the backbone of our country, but its inflexibility in times of dire situations is what we take up issue with. Think about a situation in which there is conflict. Would you rather have quicker public policy as to support you, or would you rather know that the Constitution was upheld? And so in those moments, you are going to be better supported by public policy, whether that's funding, whether that's government support, even things like hurricane relief. And so you have to ask yourself, in that situation, in that dire moment, would you rather have public policy support, or would you rather know that the Constitution is being upheld? And I guarantee many Americans would say they would rather have that support.
I think I would rather make sure that my rights and democratic principles are being upheld. I don't believe the Constitution is an obstacle in crisis response. It's a safeguard against panic-driven overreach. And in times of urgency, there is a temptation to bypass the checks and balances of the power that's the strongest, which is the Constitution. And that's precisely why we need to make sure that we're relying on constitutionalism with its built-in powers, its built-in democratic principles and values to guide us, because I'd rather make sure that public policy isn't violating my democratic right and my democratic values, not ensuring that it's responding as quickly as possible.
But my question to you is there ever a situation in which responding faster to the needs of the people is more important? Like, is there ever a situation that you guys can think of in which that would be more important?
I mean, not necessarily. Just because it's a quick response time does not necessarily mean that it's going to be a good policy that's going to be implemented. If we look at the Constitution, there are strict guidelines for how we're supposed to represent the people. So I would much rather have my rights be upheld by the Constitution and a slightly slower policy implementation than a quick policy that might infringe on my rights.
So if we had another pandemic, let's say, would you rather have some rights be upheld under the Constitution, or would you rather know that your policymakers are looking at public health and acting swiftly to address the situation?
In times of crisis like COVID-19 that you just mentioned, I would rather make sure that my democratic rights and values are being upheld. That was a lot of contention across the United States, was how were these policies that were being implemented quickly and in response to crisis and fear affecting the long-term interpretation of what our rights were. We're arguing for principled action, and that comes from constitutionalism. We don't view the Constitution as a roadblock. We view it as a roadmap to inform public policy.
I mean, during the pandemic, there was a lot of mask mandates, and they were set by states, and many argued that they were unconstitutional. But as Americans in time of crisis, we banded together and we recognized that at that moment, that's what our country called for. And so the Constitution may have reacted, but we needed the quick public policy in order to ensure that our society was healthy and protected.
I don't believe that everyone would agree that we banded together and supported mask mandates during COVID-19. There was a large group of people who actively pushed against it because they viewed it as an infringement on their constitutional right.
And we're at time. We are now ready to move to closing statements. Each team will have 5 minutes to present their argument. We will start with the affirmative team. So when you're ready,
Bear with me while I have my stuff set up over here.
no worries.
Before I begin, I would like to once again thank the judges for being here. I'd also like to thank the moderator and our colleagues. And finally, I'd like to thank my partner, Carly, who's gotten me as far as we've come today. Today, we have heard many different points and perspectives from both sides. However, after listening to all of the points brought up, we must keep the people in mind. When in conflict, constitutionalism should take precedence over public policymaking. It is our responsibility to ensure the rights and equality of all people are protected. The Constitution serves as a blueprint for governance, laying the foundation for a functional democracy by establishing the essential framework of the laws and principles that guide our nation. It ensures a balance of power, protects individual rights, and sets the standard for how our government should operate, allowing for the stability and flexibility necessary to adapting times. The design inherently focuses on preventing government overreach through clearly defined limitations and separation of power, which in turn legitimizes its authority by ensuring accountability and adherence to established principles. Our opponents try to explain that when in conflict, constitutionalism should not take precedence over public policymaking. They tell you that public policymaking is the superior option in this situation, and they bring up a few points to try and show you this. They brought up two different contentions, both trying to prove their point. Their first contention being that we repeatedly need to reinterpret the Constitution. We acknowledge this, and that is something that falls onto the affirmation side. What we're seeing is the Constitution is the backbone of our country. The Constitution is something that we will be interpreting for years to come while our nation progresses. All of the public policymaking and its interpretation is built off of constitutionalism. Constitutionalism is what we ultimately have to have precedence over. Their second contention was talking about strict adherence to the constitutionalism. They talked about the rigidity and how the constitutionalism doesn't provide enough flexibility for us to interpret it. Once again, I'd like to fall back to the point that the Constitution is the backbone of our country. We've heard lots of different examples today during Cross of how the Constitution has been ultimately what has made policymakers look back on. During COVID, we've looked at the Constitution, and what we saw is when public policymakers rushed into making decisions and didn't consult the Constitution, people were mad. People were upset that their constitutional rights were being infringed upon. Considering all of the points they've raised, it's clear to see that when in conflict, constitutionalism should take precedence over public policymaking. To reinforce this conclusion, I'll now restate the key contentions that we've presented today. First, the Constitution stands as the supreme law of the land. The Constitution provides the framework for governance, ensuring a balance of power, protecting rights, and allowing for adaptability in a democratic society. Second, the Constitution is designed to prevent government overreach. The Constitution is crafted to limit government power, ensuring that no branch exceeds its authority in protecting individual freedoms. Third, the Constitution is the social contract that legitimizes the authority of our government. Constitutionalism serves as the foundation for public policy and plays a key role in sustaining public trust. Today, we are here to discuss whether or not constitutionalism should take precedence over public policymaking when in conflict. Our burden is not to prove a solution, but rather to demonstrate that constitutionalism should take precedence over public policymaking. After examining the various reasons supporting the priority, we urge you to affirm when in conflict, constitutionalism should take precedence over public policymaking. This debate is not about old words on parchment. It is about what holds us together as a nation when everything else pulls us apart. Thank you.
Now we'll have the closing statement from the negative team.
Before I start my time, Connor and I have a few thank yous to get through, and since this is our last debate after years of competing, it's quite a long list. And we couldn't be more grateful for how this ends. Thank you not only to our opponents, judges, and moderators during this round, but the ones we've had throughout this entire tournament. Thank you to our coach Ted for debate and even Diana for storytelling. Thank you to my mom who flew all the way from Ohio, and thank you to our incredible teammates and friends who came to support us all throughout today. And lastly, we are proud to represent the University of Arizona. Tonight we argued that public policy must, at times, take precedence over strict constitutional interpretation. And we stand by that. Not because we disregard the Constitution, but because we respect it enough to want it to serve our country that is constantly evolving. That's because at the core of our democracy is a social contract, an understanding that we, the people, grant power to our government in exchange for protection, justice, and representation. The Constitution is the framework, but public policy is the fulfillment of that promise. When strict adherence to the Constitution undermines the contract, when it prevents the government from serving the people, it's not just bad governance, it's a broken promise. We saw this with the Commerce Clause, where public policy demanded action on child labor, on civil rights, on the social safety net. Strict constitutionalism would have left us powerless. We saw it during the Civil War, when Lincoln violated constitutional norms not to defy democracy, but to save it. Strict constitutionalism would have left us powerless. We saw it even again in Brown v. Board, when public policy driven by moral clarity and national urgency demanded that courts reject an original meaning that allowed segregation to thrive. There's been a lot of back and forth in today's round, so I want to take a moment to clarify the key points of the debate for everyone in the room. The first is going to be that of definitionalism on what constitutionalism is. Our opponents are trying to tell you that constitutionalism is just the values at the core of the Constitution, because that's what our democracy and the social contract is made up of. But we'd argue that there's a lot more to our democracy than just the Constitution. When our founding fathers created this, they didn't sit down and think, what's going to be written on this page forever? They thought about, what are the values, the morals we want to exist throughout society? And they thought that to be justice. The broader values are the same between public policy and the Constitution. And that's why we have to look to the definition of constitutionalism to be a rigid interpretation of it, since that's what the Supreme Court uses. Second is going to be that of who distributes rights the best. We saw in Plessy v. Ferguson that even though it was deemed constitutional, it took away people's rights. Shelby Counter v. Holder struck down the Voting Rights Act, which caused even stricter voting laws to be passed in states. Our opponents keep trying to tell you that they feel protected under the Constitution because it upholds their rights. But recognize that time and time again throughout history, we have seen where the Constitution has prevented fundamental rights within our democracy to be distributed to our constituents, breaking that social contract. You saw this again with Japanese internment camps, where it was upheld by the Constitution, especially in a time of conflict. But would we say that that was morally justified? Finally, is going to be that of conflict. Recognize that in this debate, we're not talking about when in times of conflict, meaning war. We're talking about when the Constitution and public policy are at hands. And we would tell you that time and time again, public policy is better because it's able to take those values and fundamental ideas our democracy is built off of and to be able to actually implement them. I don't think there's a single policymaker out there who wakes up one day and thinks, let me make a public policy that is unjust for our citizens. Public policy is how the Constitution stays relevant. It's how we adapt to crises, how we respond to injustice, how we uphold the social contract by making sure that government still works for the people it serves. And when we stick to 18th century solutions to 21st century problems, we do more than delay progress. Citizens United, the unitary executive theory, these weren't just legal missteps. They were policy disasters that continue to shape our democracy in corrosive ways. So let me say this clearly. Public policy isn't the enemy of the Constitution. It's what keeps it alive. A constitution without the flexibility to respond to the people's needs isn't a monument to democracy. It's an obstacle to it. If we want to preserve the incredible document, we must allow it to evolve. We must let public policy lead the way where the Constitution cannot follow on its own. That's not radical. That's what the founding fathers wanted. That's honoring the social contract we all depend on. Thank you.
Well, that concludes the final round of this year's Regents Cup. I want to thank the teams. Very good.